We're very pleased to have Dan Nippen here. He's an attorney that manages both GMA and ACCG workers' compensation claims. We've had, again, as you know, we're in the midst of a public emergency, a national emergency, and Dan is going to help us answer some questions as they relate to workers' compensation. So without further ado, Dan, take it over.
Well, thank you, Dan, and thank you, everybody, for being here this afternoon. I suspect we're all going to be doing a whole lot more virtually meeting and working in the weeks and months ahead. So it's good to virtually see all of you. If you're anything like me, obviously the monumental events that have gone on the last few weeks have created a lot of questions, and I've been telling folks I almost feel like I've had my phone stuck in my ear for the last couple of weeks with any number of questions that arise in the workplace, helping our employees and helping ourselves simply in trying to figure out what our responsibilities are and what we need to do as employers, cities and counties, especially in the midst of all of this. What we're going to be talking about this afternoon is limited to one aspect of that, but it's maybe the issue I'm getting asked about the most, not surprisingly. And that is, how does all of this relate to workers' compensation here in Georgia? What we are not going to talk about or get into too much today is all the other areas this reaches into. As we're going to see, this has an awful lot to do with sick leave, with FMLA, and with OSHA, and any number of other things that involve the workplace. And where we're going to wind up, actually, as you'll see as we go through the workers' comp aspects of this is not really a situation or an area that workers' comp was designed to be involved in. But that's not something that kind of pops out at everybody, and in part because we don't deal with what the Workers' Compensation Act refers to as occupational diseases very often. We deal a lot with what the Comp Act thinks of as occupational injuries. So really, if we're going to talk about COVID-19, viruses, and how our workers' compensation law deals with that, what you have to kind of go back to is the very fundamental beginning of workers' compensation, and a very important distinction that the workers' comp law in Georgia makes between injuries and diseases. And as I said a second ago, what we're all most familiar with dealing with are occupational injuries. Somebody hurts their back on the job. They're in an accident driving a city or county vehicle. They break a bone doing a job. There's a specific event and there's a specific physical injury. And as we're all familiar, and as you see on your screen here, there's a very well-worn phrase that's used in the workers' compensation law to deal with occupational injuries. And that is simply that the injury has to arise out of and in the course of employment for an injury to be compensable. So all we're really thinking about in terms of injuries, let's use a back injury since we see so many of those, is did this happen at work? Did this happen at a place and a time where our employee might reasonably be expected to be in the performance of their duties? And then secondarily, if they were at work, did work actually cause the accident? And it's a pretty straightforward formula, and it's what, again, we're all familiar with. I'd be a little bit surprised if many, if any of you here this afternoon have ever dealt with a workers' comp claim that involves a disease as opposed to an injury. We do from time to time, and I'll talk about a few of those. But again, the fundamental starting point is to understand diseases are not treated the way we're customarily used to dealing with injuries at the workplace. Diseases are treated completely differently. There is a very specific and separate portion of our Workers' Compensation Act that deals with diseases that are alleged to be work-related. That's OCGA 349282. You have it listed here on your screen. And if you're talking about whether a disease, in this case COVID-19, is something that comes under the purview of the Workers' Compensation Act, then you really don't think about all the stuff we just talked about and that we normally think about of, does it work related, did it arise out of in the course of employment, that kind of thing. Instead, you think about 5 different and distinct elements, all of which have to be proven before a disease is compensable under the Workers' Compensation Act. So let's talk about what those are. And then we're going to talk about why we have rules like this, why diseases are treated so much differently. There's a good reason for that, actually. And then we're going to go through the cases that have existed out there that I think might help delineate how these rules work and what's compensable, what's not compensable. So when you look at this code section that says, all right, if we're not talking about an injury, we're talking about a disease, what do we want to know? What if I'm the employee, what do I have to prove to get workers' comp benefits for my disease? It's 5 things, and you see them listed here, but really it's 2 things stated some different ways. 3 of these elements have to do with causation. The first one, the second one listed here, and the last one. And what you see, first of all, is a higher standard or a higher burden to show that your disease happened at work. If you look at the language here, it doesn't say, hey, did this arise out of in the course of your employment, which we know is meant to be by design kind of a very broad definition. There's lots and lots and lots of cases in Georgia that have talked about with regard to physical injuries. We don't try to apply these rules too terribly strictly. We're looking to grant recovery where it's reasonable to the employee. Just the opposite here. Diseases are dealt with much more restrictively. And so you see language here where the employee has to not just show that it was work related, but a direct causal connection between your work and the disease. The disease followed as a natural incident of exposure. And then if you go down to this last element, it had its origin in a risk connected with the employment and has to have flowed from that source as a natural consequence. What's all that mean? Well, what it really means is I've got to do more than just say, hey, I was at work and my coworkers were sick and I must have gotten it from them. It has to be very specific. It has to be virtually undoubted. No question that you got this from work. So that's just 3 of the things that you've got to show. And again, it all relates to a higher cause, but that's not really what dramatically limits the compensability of diseases in the workplace, or at least limits them from being brought under the Workers' Compensation Act. It's these others 2. It's the 3rd and 4th bullets here. The first is that the disease in question not be of a character to which the employee might have had substantial exposure outside of employment. And then the 4th one is really the big one that we're going to see has a lot to do with COVID-19, and that is that the disease is not an ordinary disease of life to which the general public is exposed. So when you look at these, and we're going to see this in the cases, it's not enough, even if everybody agreed, even if it was undisputed, even if nobody doubted that our employee got COVID-19 in the workplace. Perhaps it was an EMT or a firefighter, or somebody who we would all agree have a great deal more exposure to virus and diseases in general by the nature of their work than the average employee. Hospitals, of course, are running into this very same issue even more so. Nobody would dispute that healthcare workers, folks on the front lines of this, are dramatically more exposed, much more likely to come in contact with folks who have this disease and perhaps get it themselves. Even if all of that is true, you still have these other 2 elements here that if you can't satisfy these, it really doesn't matter that you have the proof that you got it at work. Workers' compensation won't cover it. And the one that most applies, I think, to COVID-19 is it an ordinary disease of life to which the general public is exposed? There's not anything ordinary about this from my or anybody else's view, I don't think. We've certainly never had an epidemic like this or a pandemic like this that has caused such dramatic changes to our lives and how we just go about things from day to day. That does not mean that it isn't something that we're all exposed to. And indeed, most of the recommendations that are coming from the CDC and from governments in terms of restricting our activities are specifically because it's something we're all generally exposed to. So it doesn't matter, again, just going through these criteria, whether you're an employee or in a workforce where you're more exposed or not. It doesn't even matter if you can prove that you got it at work or not, if the disease you're trying to recover for is a ordinary disease of life to which the general public is exposed. So for somebody bringing a claim with COVID-19, let's just say it was a maintenance worker, somebody in Parks and Recreation, and they claim, hey, I have COVID-19, I've tested positive. I think I was around people at the park or in my workplace who had it, and I want to file this as a workers' compensation claim. Probably arguable there, at least, whether he got it at work or somewhere else, but even if we assumed that he did, we're back to the fact that COVID-19 is out there. It's something the general public is having to fight and stave off. And very hard to see how it would meet that criteria. The example obviously becomes much harder if we're talking about, let's say, a nurse in a hospital who is in the ward that's treating COVID patients or suspected COVID patients. She's working with quarantine. I don't know anybody that would much contest if that individual got COVID that it was work related. The challenge again for filing a workers' comp claim would be, is it an ordinary disease of life to which the general public is exposed? And we're going to talk about a case that is almost identical to that, and how a court found that a disease was not compensable with regard to a nurse. But before we get to the cases, if this is the criteria, it a little bit begs the question, why do we treat diseases so differently in the Workers' Comp Act? Why even have all this stuff in here about ordinary diseases of life and things to the general public? And one answer to that, I suspect the primary answer, but there's others, is flu season. In our country, and oddly enough, a lot of this were statistics I think folks were looking on early on and trying to understand what the big deal was with COVID-19. Somewhere between 5 and 20% of the American population gets the flu year in and year out. A bad year obviously is closer to 20. I tried to find some data on how many Georgians had the flu in 2019. And it's a little hard to tell because the statistics and the CDC tend to talk about national figures, not state figures. But I saw in several places something like 6 to 6.5% of the population. Obviously, that includes kids and students and folks who might not be in the workforce. But it's safe to say in any given year, there's a few 100,000 folks in our state, like every state, who get the flu. For most of them, it might just be a day or two out of work. For some of them, it might be a week or two or more, and might involve some amount of medical treatment. And the reason why we have an occupational disease statute as part of the Workers' Comp Act that's been there for decades is because the comp system was never designed and was specifically designed not to cover these forms of large outbreaks. The flu obviously is predictable and happens every year. While it does kill a fair number of people every year, much like with COVID, it tends to prey upon those who are already ill or already compromised in some way. It doesn't make everybody so sick that they have to be out of work for an extended period of time, but it does even hospitalize quite a few people. And if you threw those tens of thousands or hundreds of thousands of claims into the comp system year in and year out, they would just about dwarf everything else. So the designers of the Workers' Comp Act here and in other states around the country, in thinking about that, came up with what you see, which is we don't want to deny coverage for folks who get a unique disease or something that really is a part of their workplace that we can be sure is work-related and not just something that they might have gotten or that they're going to be exposed to just by living on the planet and walking around. So that's the purpose behind the occupational disease statute and why it works the way it does. But let's talk about just a couple of cases. I think that fleshes this out just a little bit.
Hey, Dan.
I'm sorry?
We have a question from somebody, and the question is, if a firefighter works for multiple jurisdictions and pinpoints the exposure to a specific patient, is there any thoughts on that?
Yeah, much the same thing. In fact, let me jump right into it. We're going to talk about cases. One case that is almost identical to, I think, what most of the concerns are with cities and counties was decided way back in 1988 under the statute we've just talked about. The case is Fulton DeKalb Hospital versus Bishop. That involved an EMT who contracted hepatitis B. Hepatitis B is a form of hepatitis that's viral. It's passed around by bodily fluids, most typically with more intimate contact, but you can get it and actually pass it around without knowing that you're passing it around, because you can have Hep B and not necessarily be symptomatic, something that we're discovering is true of COVID-19 as well. The hospital worker EMT in this Bishop case made pretty much the same argument our firefighter in your example would use, which is, look, I work around patients. I'm incredibly exposed to Hep B, at the hospital that I work at, certainly far more than I would just in ordinary walk of life or outside of employment. So very little question that I got hepatitis B at work. but he still was denied benefits. And the reason he was denied benefits is because even though that might have been true, and even if the court was willing to agree to that, there was no getting around the fact that hepatitis B is an ordinary disease of life to which he was exposed outside of the workplace. Really, if you're looking at the statute or thinking about that example, the first question to ask before you ever get to causation is COVID-19 an ordinary disease of life to which we're all exposed? If the answer to that is yes, you really don't have to go any further. Now, so with our firefighter, obviously, is it probable that he got it from that exposure? I would concede that. It may or may not be true, but for the sake of argument even, I would say, sure, how would you doubt that our first line folks are more exposed? The statute that we have in Georgia, though, says that's not the end of the story. And the concern is not about the individual employee so much as it is the system. Again, the system was designed to handle on-the-job injuries and things of that nature, not systemic, broad-based diseases that are going to result in some of the numbers that we're seeing with COVID. So that's the answer. That's the Bishop case. A case where an employee did recover that provides maybe a bit of a contrast to this is the McCarty versus Delta Pride case. And you see it listed at the very bottom here about an employee who was a construction worker hired here in Georgia. Their work crew went out to South America to do a job, and he contracted malaria there. The employer tried to defend that case by saying, well, it's an occupational disease. He contracted it on the job, we guess, but it's an ordinary disease of life to which the general public is exposed. And the court in that case said, no, it might be an ordinary disease of life in South America, but it definitely is not in America, where it's been eradicated for a long time. So they drew a distinction there between something that is the employee was exposed to in South America and would never have gotten had he just been working here in this country. And that was enough to meet the statute and meet the requirements. Now, when you compare that again with COVID-19, that distinction doesn't exist. So getting all the way back, and then I'll be glad to open it up for more questions. The question about whether COVID-19 and workers' compensation is going to be compensable is not as much about whether the employee gets it on at the workplace or not. It's a little easier to understand the causal concern there if we're talking about an office worker as opposed to a firefighter. But even where that causal connection to us seems very clear, that's not the end of the story. And I think the bottom line for COVID and workers' comp in Georgia is it's an ordinary disease of life, unfortunately for all of us. And because of that, it doesn't meet the criteria that would make it compensable under our Workers' Compensation Act. And I'll kind of end before we get to the questions where I began. Now, that does not mean that we don't need to take care of our firefighters and our EMTs. There are other forms of benefits that not only can be available, but should be available. And as most of you have probably seen in the news, going back about a week now, Congress has been actively working to create federal legislation. It got through the House last Friday. It's in the Senate now and is very likely to be passed this week. The final language is still being played with, but one thing that's very clear is that it's going to create some form of federal sick leave benefit. How that's paid for, whether part of that is to say to employers that if you don't provide already, you're going to have to provide a paid sick leave benefit. We won't know until the Senate gets done with it and the president signs it. But that's another indication that again, even if this is not something that our Workers' Compensation Act contemplates, there are other things at play that are very likely to be heavily involved in helping folks who contract this on the job or otherwise. So, all right, that's enough of me talking about how the compact works and what the occupational disease statute means. What other questions do we have that I can try to answer for you?
Here's a couple, Dan. First one, how does that differ from HIV or TB that we do a baseline testing?
So is the question, does workers' comp cover the testing for that?
Well, really about HIV and TB. What's the difference between that where they do baseline testing so they can determine?
Gotcha. So the question is, what's the difference between COVID-19 and viruses or diseases like HIV or tuberculosis and testing for that. To me, from a legal standpoint, there's two different questions there. The first one is, would HIV or tuberculosis be compensable? And again, same elements. Whether that is something that is an ordinary disease of life, the general public is exposed. I don't know if that would, it might very well be your question for HIV and tuberculosis, because very much like malaria, for example, those cases, while those are out there in the general public, certainly the general public can be exposed. Much like malaria, those have been much more confined and dealt with as years have gone on, tuberculosis in particular. So in terms of whether those are compensable or not, that would be a closer question and one you want to look at. As far as testing is concerned, there's another line there. For example, somebody with COVID who says, hey, I'm afraid I've been exposed and I want to be tested. There are CDC guidelines, and everybody from the government on down has been saying testing is vital. It's imperative that folks who meet the criteria get tested so we can determine if they are in fact infected, and if so, get quarantined. Whether that has to be done under workers' comp or not, though, is not so clear. I would say no, for the reasons we just talked about. It's abundantly clear that this is not a compensable occupational disease. So while testing needs to be done, absolutely, I don't know that it would be something that would be covered under workers' compensation.
Here's the next question, Dan. Our city's solid waste staff enters residents to pull the garbage containers from the curb and returns. My question, if they entering so many residents to provide a service to the public become sick with COVID-19, are they eligible for workers' compensation?
Yeah, another example of folks, actually, other than the kind of first line healthcare fighters that we think of, who might very well be more exposed to COVID than the average population. But again, each one of these questions, and I get it, get back to the same issue. Whether the trash collector actually got COVID on the job or not would be a closer call than say a healthcare worker. But for both of them, you still run into, are they more exposed? Perhaps. Doesn't change the character of COVID. COVID is all over the place, so much so that we're having to shut down virtually all kinds of significant public gatherings. So it's definitely something that is in the population, and the general public is exposed. So no matter the level of exposure at work, at least in Georgia, where we have this statute, the fact that it is something to which the general public is exposed negates the compensability.
Very good. Any other questions? I'm sure you guys have some more. Any other questions? The question is, did Dan K say Congress is looking at a federal sick leave policy?
Yes, I did say that. You can actually, if you go on the web, although I would almost encourage you not to do that, because when you do, what you'll see is several different versions of this bill. There were several floated around in the Federal House of Representatives last week. They eventually passed a bill late Friday night that has made its way over to the Senate. And so it's a little confusing looking around the internet on what is or isn't in the bill. What's safe to say at this point is that the bill in all of its forms has included several things. Funding, for example, for testing, which we're seeing being addressed in lots of different ways. That's really a question of funding and getting the industry's getting ramped up enough to produce the tests. But the other thing that's clearly going to be in this bill when it gets done, and I would expect it to get done this week because of the urgency, is some form of mechanism for paid sick leave for folks who actually are diagnosed with the virus or are having to quarantine themselves, or there will be a list of criteria for that. What's interesting about that to me is, as you all know, we've had the Family Medical Leave Act for some time, which is unpaid leave. And there has been a movement for quite some time now to kind of amend the Family Medical Leave Act to require some amount of paid leave as well. Now, for most workplaces, that's something that already exists. and it might or might not be that big a change. But what this particular bill is contemplating is and again, different versions, so it remains to be seen whether it comes out as a requirement that employers pay for some amount of sick leave if somebody is diagnosed or quarantined, or whether that's a federal government benefit. One of the bills I know contemplated doing that through the Social Security Administration, not with their funding, but since they're already set up to handle disability claims and things of that nature. So I'm not sure which way that's going to wind up. What I feel pretty confident about is the political pressure for that to happen is significant. Everybody seems to be on board with that getting passed and through quickly so that it can start being used. But again, what form that takes is probably being negotiated right now, and we'll just have to see what the final ruling or the final law is when it comes out.
And somebody had a question, will we push that out? Will LGRMS push that out? Yes, we will, within coordination with ACCG and GMA, will provide you with that information on specific legislation that has been passed. So here, so if an EMT comes down with they will not be covered.
Would not be covered under workers' compensation. I think that is absolutely right.
Very good. To confirm, COVID-19 is considered not an ordinary disease. To determine where the employee picked up the disease is the main issue.
No, I would say the main issue is that it is an ordinary disease of life to which the general public is exposed. Secondarily, the issue is, did the employee get it at work? And I think what we're seeing as we've kind of thought through all of this is there are some types of workforces, and again, I'm thinking of nurses, EMTs, firefighters, those folks that nobody would disagree are much more exposed to this by the nature of their work. I think that's a given. I don't think anybody is arguing about that. And I think the natural question that comes from that is, well, gee, these folks are putting themselves out there for all of us to help keep us safe and to do their jobs. Absolutely. But then the next, where everybody goes from there is, well, then why would that not be compensable? And again, the answer to that is not because of the causation in their circumstance. The answer to that is this is a disease that the system is not meant to handle, much like the flu. And whether it's the federal legislation or the sick leave policies and things that we already have in place, that is not to say that these folks should be left holding the bag or that there's no help for them. There is. And it's just, again, not something the workers' comp system was designed for.
So here's a question. FMLA requirements only apply to employees with 50 or more employees. How will this affect businesses?
That's a great question. The Family and Medical Leave Act, it does apply to all cities and counties regardless of size, but as far as private employers go, it does not apply if your workforce is 50 or less. Part of the federal legislation that's being kicked around this week is obviously meant to address that, because obviously this illness doesn't matter how big your employer is. So the answer to your question is, if Congress were not doing anything, FMLA wouldn't cover this for small employers either. But I think that is one of the loopholes, or one of the gaps, maybe that's a better term, that Congress is trying to address this week.
Very good. Any other question? I mentioned at the end that HR questions may be directed to ACCG and GMA helpline. Oh, that was a statement. So again, I think as we would like to direct, if you have any specific questions regarding HR benefits and you're a GRMA or IRMA member, please direct your questions for specific information to the HR helpline. They'll be happy to help you out in any of those particular questions. Anyone else with any questions? Well, Dan, thank you so very, very much. We really, really appreciate your time. You did a great job for a very, I'm sure answered a lot of questions with that information. And I'm sure you would be willing to provide service and support to any of these members if they need that from a workers' compensation and other legal advice. Is that correct?
Well, absolutely. Thank you, Dan, and thank you, everybody. And again, know these questions and tough issues. So as others come along, please don't hesitate to reach out. And as Dan said, particularly to the ACCG and GMA helpline. A lot of good answers there as well.
Thank you so much, Dan. Thank you so much to all of you that attended. Stay safe, stay healthy, and let us know if there's anything we can do at LGRMS to help. You guys have a great day.
Bye, everybody.